Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have received some questions, some comments, and have noted discussion in the general community. Why is Washington State University the defense in the federal lawsuit styled as Goncalves et al. Versus WSU seeking to change venue in this case that has been proceeding in federal court in the Western District of Washington Federal Court to the Eastern District of Federal Court, which is where WSU is seeking this transfer to happen. The answers to those inquiries, we believe, can be found in two documents filed Friday, January 30th, 2026. The first, document number 8, motion to change venue with a noting date of February 27th, 2026. The second is document number 9. This is a declaration of Cheryl Camerzel. She's a representative of Washington State University, and it was filed in support of the motion to change venue. In a nutshell, what WSU is arguing is that the potential witnesses, the evidence, the events that were addressed in the complaint occurred in the Pullman-Moscow area. For example, the campus where the plaintiffs alleged violation of the federal statute Title IX occurred, which the defense aggressively denied occurred at the main WSU campus in Pullman. The complaint also asserts that Mr. Koberger, who, although not a party in the case, his name is all over that complaint. He attended school at the main campus in Pullman. That's where he worked as a teaching assistant, and that's where he lived in off-site housing. Everything occurred in Pullman. The declaration in support of this motion to change venue outlines the names of many, it appears to be potential witnesses employed at WSU who, according to the declaration per HR records, live close to the Pullman campus of WSU. So the defense has raised the argument that on these grounds, it makes perfect sense, at least according to them, for the case in the Western District to be closed, for the lawsuit to be transferred to a courthouse closer to the Pullman area in the eastern part of the state, where if this motion is granted, a new case will be opened, a new case number assigned, a new judge assigned. Everything depends on what the current judge in this lawsuit, the Honorable Kimberly K. Evanson, rules after this noting date of the 27th of February that's listed page 1 of the motion to transfer venue. Now, how does plaintiff feel about this? What is their position? Do they agree that the case should be transferred? Do they disagree? After all, they filed this case in state court, Skagit County, which is in the western part of the state. Maybe they don't want the lawsuit moved. Maybe they want the lawsuit to remain in the area where they filed as plaintiff, that they have a right to decide where a lawsuit should proceed. The answer to that question remains undetermined at this time because a review of the docket this morning reveals that the plaintiff's response has not yet been filed. But as of right now, the motion remains pending with the court, meaning it has not yet been ruled upon by the judge. This will be the first and possibly the only ruling, depending on what her order says. In this case, if she grants it, or if it's denied, the case will continue where it is in the Western District Court in Washington, and you will likely see a scheduling order come out sometime soon after the ruling on the motion to transfer venue occurs, because what the court did is on Thursday, February 5th, 2026. It's document number 15. There's a notice to the parties where the court acknowledges the requirements of Federal Civ Pro 16b2, which required a scheduling order, but finds that good cause exists to defer the entry of a case schedule pending its ruling on the defendant's motion to change venue. That case scheduling order is going to list items that Rule 16b2 says must be in that case scheduling order to ensure that the case proceeds in a timely and efficient manner. Two things that will need to be in that case scheduling order is, number one, the deadline for the parties to conclude discovery. Discovery is extremely important in litigation because that's where the parties will serve requests for production of documents, typically, interrogatories, requests for admissions, schedule depositions in an effort to gather evidence. Another item which must be in that case scheduling order would be a deadline to add any third parties. For example, WSU decides per affirmative defense number 1, where they reference that there could be other persons or entities responsible to the plaintiffs for any damages they suffered, and WSU denies that they suffered any damages that could be recoverable in this case. This case scheduling order must have a deadline for third-party practice. In other words, for WSU to seek as a third-party plaintiff to name and to essentially sue a third-party defendant in this case. That's another deadline that you're going to see that the rule says must be listed in a case scheduling order. Sometimes there'll be other things that may be included in a case scheduling order, such as a proposed trial date. The plaintiffs have demanded a jury trial, so there might even be a date for trial listed in that case scheduling order. But again, as of right now, per the court's ruling in that notice to the parties, no case scheduling order is going to come out until or unless, effectively, the motion to transfer venue is denied. Because if it's granted, this court will not be putting out a case scheduling order. That will be something, if the case is transferred to the Eastern District, that the assigned judge will be doing after a case is initiated there. We're going to continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.